Very well, Snehal. So we had a question from one of our listeners, and I wanted to put that to you. What can I do if my case has been denied by immigration? Is it even possible to appeal?
Sure, yeah, that's a great question because of course, we do see denials, right? Well, the simple answer is yes, you can appeal in most cases, and the denial letter that you get is going to provide information about what options you have about the decision. If you can appeal or motion, is going to talk about how much time you have to do that and also where you need to file that. However, we almost never want to file an appeal or a motion. In most cases, we advise our clients to just refile the case. And that's what you do. You just refile the case and immigration is not going to hold it against you. The legal terminology is denied without prejudice, meaning the case has been denied without prejudice and you're welcome to file again. And, as much as we want to challenge and fight this bad decision, most of the time it's best to refile the case. It's not worth pursuing. Of course, it depends on the grounds, for the appeal, but the success rates are fairly low. Why? Because immigration very rarely overturns their decision. So that's something to be mindful of when you're whether or not to file an appeal. And another thing I want to mention here is that once your case is denied, you can go back to, you go back to the status that you had at the time you filed. So by filing an appeal or a motion, it doesn't keep you in status. A lot of people sometimes are confused about that, right? They think, my denial says I have 30 days to file an appeal and I have, I can stay, but that's not the case. If your underlining status is expired, you have to be mindful of accruing unlawful presence and all that. So these are really important things.
Yeah, thanks for bringing that. Actually, a lot of people mistake that for, just carrying on and being in status then.
Right. And another important thing that people maybe are not aware of is that only the petitioner can file the appeal. So if your employer filed a case for you like an H-1B or I-140, and it was denied, as much as you want to challenge that, you can't as a beneficiary. Only the petitioner has the right to file that appeal. So, there are some limited circumstances, like if you're filing a WAWA self-petition, you can appeal, but, it's not the case for most people. And I also want to mention the difference between like an appeal and a motion, because the denial letter will say, you can file an appeal or you can file a motion. So the appeal is when you're requesting a different agency to review that decision, where the motion is you're requesting the office that issued the denial to review the decision. It could be like a motion to reopen, where you're requesting immigration to review the decision based on new facts that you have, like new evidence, or a motion to reconsider because they made a decision because they incorrectly applied the law. So these are some possible options. But again, unfortunately, most of the time, appeal or motion is not a good idea. They don't like to overturn their decisions, and there's no processing time. Like they can take as long as they want to take to consider your appeal or motion. So a lot of times by just refiling the case and tightening up the case, right? Because now perhaps there's a weakness in the case, and when you refile, you can tighten that up, tie up any loose ends, and refile. And, it doesn't hurt the chances of success. And let me just say one other thing, because I know a lot of my Indian clients feel that a denial means like a rejection, they have a bad case, but keep in mind there's one immigration officer reviewing your case and they make a decision. And the standard that they should be using is the preponderance of the evidence, which means like if it's more likely than not true, they should approve it. But unfortunately, some officers we know interpret that to mean, 99%. And that's not something that you're going to be able to overcome, because it's impossible to convince them.
Yeah.
So it may not be worth pursuing that and just refiling. But
So if
doesn't
you're
mean there's
refiling,
something
sorry to
wrong.
interrupt, but if you're refiling, does it go to a new officer or does it
Yes,
still?
that's a great question. Absolutely. And a lot of times, believe it or not, it might even end up going to a different location because immigration changes filing locations all the time. So they will have in their system, of course, the record of your previous filing, and you have to disclose that when you refile the case. So, but it doesn't mean you can't include more evidence.
Wow, great insights right there, Snehal. Thank you for that. And that's Snehal Batra of the NPZ Law Group, helping you with the A to Z of immigration, green cards, marriage cases, H-1B, visas, and more. Call them today at 201-670-0006 or log on to visaserve.com and get a special